So I guess we could start, and if there are any more people joining in, we'll probably miss just my part of the webinar. Good evening to all. I'm very honored today to introduce you to three outstanding colleagues. I'll start with Paralika, good friend, colleague originating from Greece, but who's been in Paris for many, many years now. Marily is currently the head of international arbitration at Field Fisher in Paris. She was previously with White & Case, and before that, the deputy counsel at ICC. She's a member of the ICC, International Court of Arbitration, and as well as the Commission on Arbitration and ADR. And she's been very active and a member of the board of directors of Arbitral Women. She has over 15 years experience as counsel and arbitrator in international arbitration proceedings. Her experience including cases under ICC, ICSID, LCIA, and SCC rules, in cases relating to construction, engineering, infrastructure, energy, M&A, shareholders disputes, and other matters. She's the author of many articles and a regular speaker at arbitration events all over the world. Marily will start by discussing an issue which is very important and of particular interest to Cypriot practitioners, which is what is the role and importance of the place of arbitration. Before I give the floor to Marily, let me introduce the other speakers as well. We have Thomas Granier, another key figure in international arbitration. He's currently counsel at Asafo & Co. in Paris, where he focuses on arbitration and enforcement proceedings before French and African courts. He's a co-founder of Delos and the co-editor, and is co-editing the Delos GAP together with Hafez. He has acted as arbitrator and counsel in approximately 25 arbitrations under the rules of ICC, LCIA, ICSID, HKAIC, DIS, Delos, as well as the Common Court of Justice of Arbitration in Abidjan. He speaks English and is also fluent in French and German. Thomas will talk to us about the GAP and also will give us some background to Delos and how it was set up and what its purpose is. Last but not least is Mr. Hafez Virjee, another key figure in international arbitration. Hafez holds degrees from Cambridge, Université Paris and Berkeley in California. He's a solicitor of England and Wales and is also qualified as an advocate in France. He's the current president and co-founder of Delos and acts as an independent arbitrator in Virjee arbitration. He previously served as an independent arbitrator, as counsel in international law firms in London, Paris, and Dubai, and he has experience in a very wide range of industries, commercial relationships, and clients. He's a co-editor of GAP, Delos Guide to Arbitration, together with Thomas, and regularly writes and speaks on international arbitration and related matters. He is listed among the future leaders of arbitration by Who's Who Legal and was ranked in 2020 among the most highly regarded for Europe. Hafez will talk to us about the Delos rules of arbitration, will share with us some know-how on contemporary matters such as COVID-related issues, webinars, and the use of technology. And lastly, we'll talk to us about the training and the London Arbitration Centre, which is launched by Delos. With these introductory remarks, I would like to give the floor to Marily to start. Thank you.
Thank you very much. Thank you very much, Agis, and many thanks to Delos as well for the invitation to participate in today's webinar. I very much regret not being able to do this in person in sunny Cyprus. I hope to return to your beautiful country very soon. Now, turning to the place of arbitration or the seats of the arbitration, it is one of the most important features of the arbitration clause. And I think it's worth taking the 10 minutes that I have been allocated to discuss why what the seat of the arbitration affects, why it plays such an important role, and hopefully have some time to also address how to choose the right place of the arbitration. So the seat of the arbitration is a legal concept. It's not necessarily the geographical place where meetings or hearings may take place. That doesn't mean that hearings cannot take place at the seat of the arbitration, but they don't have to. The seat of the arbitration determines two very important things. The first is the law that will govern the arbitration, the lex arbitrii. And the second is which courts will exercise jurisdiction over many crucial matters that may impact on the fate and the life of the arbitration. So the seat is where the arbitration takes place, as we say very often, or where the award is rendered. It is supposed to be rendered at the seat. Now, we should distinguish the venue of the arbitration, which is the physical location where a hearing can take place or where the tribunal's deliberations may take place. The two do not have to coincide, as I mentioned previously, but I think it's important to stress this because I have found that there is often a confusion between the seat and the venue. And many parties or practitioners may have a view that the seat has to be the same as the venue. Now, I want to discuss briefly those two important reasons why the seat is important. First, the impact of the lex arbitrii in the arbitration and the role of the national courts. So what does the lex arbitrii govern? So that is, again, the law of the arbitration at the seat, at the city where that the parties have determined as the seat of the arbitration in their clause. The lex arbitrii will govern many things, and I will mention a few. It typically governs issues of arbitrability, the extent of the party's right to resort to arbitration, basically, the powers and the duties of the tribunal, of the arbitrators, the rules for the constitution of the tribunal, the rules of procedure, and the effects and validity of the award. It should not be confused with the law applicable to the underlying contract. One should not think that because the law applicable to the contract is English law, for example, that will necessarily be the lex arbitrii. If the seat of the arbitration is outside of England, then a different lex arbitrii will be applied to the arbitration. Now, some may argue that the role of the lex arbitrii may have nowadays become residual and limited to filling gaps that the parties have not expressly dealt with in their arbitration clause, or to filling gaps that in cases where there are no arbitration, to fill in gaps in case the arbitration rules do not provide for it, which is in practice rare. But I do think that we should not lose sight of the importance of the seat of the arbitration, because we should not forget that arbitration is not harmonized at the international level, and there are differences between the laws in different countries. Also, the New York Convention governs two important elements, which is the enforcement and of the arbitration agreements and awards. But there are many other matters, from the appointment of the tribunal to the setting aside and the nature of the review of the tribunals, or even the binding effect of the arbitration agreement to non-signatories, that are not harmonized at an international level and may come into play in any arbitration. Now, the impact, turning to the second element that I mentioned, the role of the national courts. When and how can local courts at the seat of the arbitration intervene in an arbitration? First of all, I would like to stress that the role of the national court should not be underestimated. And that is, among other things, because local courts have a prerogative that arbitrators do not have. They have coercive powers, and their role should be taken into consideration. So when can the national courts of the seat intervene, and what is the impact of such intervention? So they can assist in the constitution of the tribunal, especially in arbitrations that are not administered by arbitral institutions. They can assist in providing provisional measures, for example, when these are needed prior or after the constitution of the tribunal. They can also assist in gathering of evidence and on deciding on actions to annul and enforcing awards. So they do cover a wide spectrum of areas that can affect the life, but also the outcome of the arbitration. Another important thing to bear in mind is that local courts can also obstruct, not just assist the arbitration, but also create obstacles, unfortunately. For example, what happens if local courts accept jurisdiction over a dispute despite the parties having agreed that their dispute will be resolved by arbitration. They can also obstruct an arbitration by setting aside arbitral awards by, for example, deciding to consider the merits of the case, something that normally they should not be allowed to do, especially not and definitely not in countries where the New York Convention is applicable. Now, how to choose the right seat and what is the right seat? Now, first of all, a question of form. It's very simple to insert a provision about the choice of the seat in the arbitration clause. One sentence is enough to say the place of arbitration shall be Nicosia, Cyprus, shall be New York or Paris. And again, I want to stress again that the seat of the arbitration can be anywhere, does not require any connection with the subject matter of the dispute or with the parties. So the factors to take into account obviously have to do with the elements I just discussed. One should look into the local arbitration law. It should be modernized. It should be arbitration friendly. It should not hide surprises that might lead to an annulment of an award that would not have otherwise been annulled somewhere else. The state of the seat should be a party to the New York Convention. The attitude of the local courts should be taken into account. Judges, it would be good for judges to be familiar with and supportive of international arbitration. And up until recently, parties would take into account the convenience and cost of the hearings. And this we will discuss later. And this only because parties would try many times to have the hearings at the seat of the arbitration. Now, briefly, I want to mention an interesting piece of information. 5 years ago, the Queen Mary International Arbitration Survey, now it dates 5 years ago, but still it's an interesting insight into what users think about the selection of the seat of the arbitration. And the survey showed that the primary factor that drives the selection of the seat for the parties is its reputation and recognition. But also the seat's formal legal infrastructure. By that, we mean, well, users have in mind apparently neutrality and impartiality of the legal system, the national arbitration law, and the seat's track record for enforcing agreements to arbitrate and arbitral awards. I think I don't have the time to go into what happens if the parties do not agree, if there is a lack of agreement on the seat of the arbitration. Things can be easy when there is an institutional arbitration in place. They can be a little bit more complicated in case of ad hoc arbitrations, and even more complicated when the parties cannot agree in such cases on the constitution of the tribunal. So we'll just end by circling back to my initial comment that the seat of the arbitration is indeed an element that plays a major role in the life of the arbitration and must be chosen carefully. It is important to consider the local arbitration law, the local courts, that they should be arbitration friendly, and just remember that it only takes a sentence in the arbitration clause to settle things that can have an impact in the proceedings. Thank you very much.
Thank you, Marilee. Before I give the floor to Thomas, I have a question for you. What new considerations, if any, have to be taken into account today in selecting a seat, given the increasing use of video conferencing and other forms of technology in arbitration? Are we, will we be looking for jurisdictions that are pro-technology biased?
Sorry, excuse me. Excuse me, Agis, was muted. It's an interesting question. I think that with the increasing use of technology, parties should look into, make sure basically that the players in an arbitration hearing, and by players I mean the parties, their lawyers, experts and witnesses, and the tribunal do have access to infrastructure that allows them to participate in virtual hearings without hurdles. I think that to a certain extent, and I think I briefly implied that in my presentation, to a certain extent, this was an element that had always been taken into account when selecting the venue of the hearings. Parties would look into the facilities that are available in London, in Paris, in Geneva, in Athens, or in Nicosia. They would be aware of where they could hold a hearing that is cost effective, where there is enough space for breakout rooms, for hearing rooms, etc., and for the length of the hearing. So I think that indeed, there will be an extra element for parties to consider. I'm not sure that that will necessarily favor pro-technology jurisdictions in some way, but these considerations, I think, will need to be carefully taken into account, especially when, for example, witnesses may be unable to travel and may be based in countries with infrastructure that does not allow them proper preparation or a proper link that functions properly for them to testify. So yes, I think we will start looking, even see countries in, to be lists of countries to be avoided, for example, for the purposes of conducting virtual hearings, because they don't have a good internet infrastructure. But yes, so I think that this recent evolution will just add a few more things in our usual list of things to prepare for going forward.
Okay, thank you for an excellent presentation, Marilee. So let us now turn to Thomas, who will talk to us about the GAP and give us an introduction to Delos. Thomas?
Very much, Agis. So you've heard from Marilee, who very eloquently explained how important arbitrating in a reliable forum, in a reliable arbitral seat is. But the problem is that the business operators do not necessarily know whether the place of arbitration upon which they agree in their arbitration agreement is safe, if it's just okay, or if it's really risky. And the problem is that, and for instance, risky, for instance, if it presents a very high risk of high interference of the judiciary power in the arbitral process. And the problem is that, as Marilee explained, it's so important, the place of the arbitration, that if you pick the wrong one, that might cost you a lot, because you might end up fighting parallel court proceedings, etc. And that's, in fact, honestly, that's fine. That's fine to pick a risky place of arbitration. What is not fine is not knowing it in advance. Why? Because it's a matter of contract. It's a matter of risk assessment. And the idea is that business operators, when they choose an arbitration place, should be provided with the means of easily knowing what they should expect from the place of the arbitration. And that idea, that concern was at the heart, and still is at the heart, of the Delos Guide to Arbitration Places that Hafez and I are co-editing under the chairmanship of Professor Maxi Sher and Professor Jung-Gi Kim. So that's really the driving idea. Now, how does it work? How do you get to the end game, which is providing corporate decision makers and business person with a simple corporate tool that helps them determining whether an arbitration place is safe or not? The Delos Guide to Arbitration Places, the Delos GAP, is here for that. So it works in chapters. We have contributing firms, approximately 60 firms, in approximately 60 jurisdictions, I'm rounding up a bit, that each provide a chapter setting out explanation about the most salient features of the arbitration framework in which they operate in their jurisdiction. And each of these firms these features, these salient features, they are the same throughout the chapters that you find in the Guide to Arbitration Places. And these firms then, at the end of the chapter, they assign traffic lights: green or good, yellow, this aspect might be a bit risky, or red, here there is a red flag in respect, for instance, of the familiarity of judges with arbitration and therefore their tendency to interfere with arbitration. So once you have this traffic light from the firm, you have reviewers who review the chapter, who are experienced arbitration practitioners, and who state if they agree with the traffic light that has been assigned. And generally, the firm and the reviewers are in agreement. Now, all these explanations for what? Well, at the end once all the chapters have been finalized, you have a wonderful guide with wonderful explanations that is easy to read. If you need, for instance, to know everything about arbitration in Cyprus, then we know exactly where to go. We have Agis Georgiades who have prepared the chapter. But at the end of all this, you have a table that is very easy to read, and perhaps Hafez, if you have a link to the website, we can display it to on the screen. So you have a table that that basically shows all the traffic lights for all the jurisdictions in place, and it's very easy, very easy to read. And that's on the screen, I believe. Right. So as you can see, you just need to go through. It's only a few pages. It's very easy to find the jurisdiction and then to identify whether it's all green, whether there is a bit of yellow, whether there is a bit of red. And so the all green ones are what we call the safe seats, but just the Delos safe seats. They're the ones where basically you can go with closed eyes. You can sign up for them. Now, let's be very clear. The purpose of the gap is certainly not to allocate good points, bad points. Being all green is not a reward. Having a bit of red is certainly not a punishment. The concern and the approach is really to assess, to help corporate decision makers to assess their risks when they choose a particular seat and exactly where the risk lies. The gap so far has been a tremendous success. As I said, we have approximately 60 law firms that contribute chapters to the guide, and there are more when you include the reviewers. There are more than 200 people working on this project and who are using the gap chapters. And as another token of that success, in 2019, the GAP has actually been nominated by GAR for the GAR Innovation Award. This is a very nice collective achievement of all the persons that are working on it. Now, that concludes the explanation about the GAP, and very briefly about Delos, because the GAP operates in the framework, in the broader framework of Delos. Delos, which I like to call an arbitration platform. Initially, it was only an arbitration institution that was created in 2014. Now it still is an arbitration institution, but it's also, thanks to the GAP and other devices, such as the many webinars that Delos produces. It's also a knowledge sharing platform, and very soon it's also a hearing operator, a hearing service provider, remote hearing service provider, which actually I have used in the past in the context of hearings very recently, and Hafez will touch upon that. And it will soon be a hearing center operator. I believe I've exhausted my time, so I would just conclude that.
Thank you, Isma. I have a question for you. Because, okay, I understand that Delos is a platform which is producing this intelligence, and that there are ways to double check the information that is uploaded so that it is reliable, and for that reason it is it appears to be a very useful tool to the practitioner. But turning now to to Delos as an institution, as an arbitral institution, is there really a room for another institution? Are there too many institutions around? What do you think?
You're absolutely right. Arbitral institutions have actually the number has increased like mushrooms. Just in Africa, there are 54 countries, but more than approximately 19 arbitral institutions, and you would find similar statistics throughout the world. Now, is there room for Delos? It's an interesting question. It goes back to the roots, to the creation of Delos. I remember that in 2014, when I had left the ICC, Hafez and I met with startup incubators, very important ones in the Middle East. The story was that we thought it was for a potential case, but in fact, their need was different. They wanted what they called at the time an arbitration device, an arbitral institution actually, that would allow their startups to resolve disputes in less than 6 months. And time was of the essence, because beyond 6 months, the potentially some of these startups would actually just die without a final decision. And our approach at the time with the seven people that founded Delos was certainly not to create another institution to put our name on it. Far from it. We looked at what existed at the time that would allow that. At the time, there were no expedited proceedings. It was 6 months was not conceivable actually, and less than 6 months was difficultly conceivable. And so that's how actually we came up with the idea of creating an institution that would make that happen. That's the first step of the story. The second step of the story is that Delos met that promise, because the first award was issued in the first case, was issued in 3 months from the request for arbitration. Not a big case, but meeting the promise made to startups. But then there is a second step to that story, and I'll just shut up. But the second step is very important, because a lot of law firms that became aware of this initiative and of this first case asked whether actually Delos would expand its scope, its reach beyond the startup economic segment, which had requested basically the creation of Delos. And the answer was obviously, why not? That was explored, and today, I believe Hafez could confirm, but Delos is clearly administering cases that go beyond the economic sector of startups. So to answer your question, yes, there is room for Delos, because actually Delos is the creator of the demand of an economic sector which didn't find in arbitration as it existed then what it needed.
Okay, thank you very much, Thomas, for sharing this interesting information with us. Now let's turn to Hafez, who will talk to us, who will start with the Delos rules of arbitration, and then we'll share some additional knowledge with us about know-how and about other activities of the Delos institution. Hafez, please.
I'll be very happy to. Thank you, Agis. And as well, thank you everyone for joining us. It's a privilege to be able to share about what we've been doing with the Cypriot arbitration community, and we're grateful to Agis for his warm welcome and for hosting this. I'm going to tell you a few words about Delos, about the institution, and as Thomas was saying, about Delos as a platform. And so maybe to start with our rules, they're organized around 4 principles. The first one is, stepping back further, as Thomas was saying, the starting point for designing Delos was a request for efficiency in arbitration. So we were looking at how do we meet that need. And in looking at that, we took a comprehensive view of our practice of arbitration to see everything that could be made more efficient, whether interests were aligned, and if not, whether they could be better aligned to achieve a better result. And where we came out was that there were 4 broadly core areas that we could focus on to improve efficiency in arbitration, and we described those as pillars. The first is you want arbitrators who are proactive, but the challenge with being proactive is if the seat is not supportive, because otherwise you may be taking a risk on the reward, hence the notion of safe seats, which both Marie-Lie and Thomas were talking about. Thirdly, when we talk about time in arbitration, we tend to start from when the tribunal is constituted, but actually a lot of time goes into constituting the tribunal. And so we looked at how we could improve that. And fourthly, if we're going to take a wider angle, then there are other things to consider as well, such as what can be anticipated upfront that can make you gain time much further down. And one example is confidentiality of arbitration. You've probably had a case where you've wondered, okay, my client wants this proceeding to be confidential. It's not written in the arbitration agreement. Do I look at the contract? Do I look at the rules? Do the rules say anything about it? What about the national law? How do I go about it? And so you end up wasting, or spending rather, time and energy in answering the question, discussing with your client, considering whether you make an application, and possibly arguing that with the other side if they're in disagreement, whereas you could have upfront had a clause in your contract that said, and the arbitration will be confidential, just a 1 sentence. But to have the presence of mind to think about it, we included it as part of our model clauses. So the general theme here is we looked at every aspect of our practice to see how we could make things better, how we could reduce actual costs and reduce potential costs. And because I'm aware of time here, I'm going to share, if I can find what I'm looking for earlier. I was struggling to find on my screen what I'd set up to share with you. So I guess I got the same issue now. I guess I'll just have to find it. There was a page on our website which I thought you might find useful. So if you go to our frequently asked questions, one heading is the institution. You open this, and you'll find that under question 3.4, the question, what are the distinctive features of Delos arbitration? And as you can see here, it's a summary version, but as you can see, we looked at every aspect of the procedure and how to improve the procedure. I'll let you navigate in your own time. And then I mentioned the pillars earlier. If you go to the rules section of our website, on the commentary, you will find a much more detailed description of the 4 pillars I mentioned, as well as articles if you want to go further. So that tells you about Delos as an institution. Delos is also other things, and I'd identify perhaps 4 other areas of activity. One, you might say, is thought leadership. And the bigger picture here is, if you're going to innovate, you want to stay at the forefront of thinking on a number of issues, because it keeps your system at the cutting edge, and it means that you're also serving your community. And I'll give you a couple of examples of what we've done by way of thought leadership. Actually, I'll go to our know-how section. And here you'll see that we, in the context of the pandemic, we've done a few publications which may be of use. One is, if you think about the issues that the pandemic has given rise to, one set of issues is substantive. And so to facilitate access to information, bearing in mind that a lot of law firms were putting out guidance, were putting out summaries on relevant issues, we put together a resource page that organized that guidance so that it was easy to locate. If you cast your minds back to the first half of March, there was still a feeling that we might be able to do hearings physically. And at that point, everybody was wondering, okay, but if they're physical, how do we go about them? Do we need to postpone them? Will we be able to travel? So in March, we also put out a checklist on how to hold hearings in those circumstances, which has since been translated into Chinese. And those resources have all been nominated this year for a prize by GAR. As we were doing all this, so at that point, you're March, then fast forward April, May, people started having fully remote hearings, but there was a big question as to how do you manage those? What should you be thinking of? And then the next stage was an inflation of publications and know-hows and experience sharing, to the point where it was difficult to find your way and to know what to look at. And so that prompted us to put together a resource page so that it was easy for people to navigate the resources available on the topic of remote hearings. Now, that's all very well, but there was also a question in our minds as to what is this phenomenon? How big is it? Who's involved in it? What are people thinking about it? And is it here to stay? And this will tie into some of my other comments. But the point of mentioning all that is we then ran a survey in June, July, which over 200 practitioners responded to. And one of the findings of the survey was that fully remote hearings are here to stay. They'll be part of the toolbox. Practitioners do prefer physical hearings if the day we can go back to them, but probably for shorter hearings and CMCs, we will keep doing virtual hearings. Now, keep those thoughts in mind. as we were looking at how to continue meeting the needs of our users and the community in 2018, we took the decision to, in 2019, set up a new hearing center in London, which is known as LONDAP. And we took our time to do so that we were sure that it was the right setup for the right needs. And with the pandemic and all the discussions that have happened around remote hearings, we took a step back to say, okay, so how have these needs evolved? And we looked at the data we got from our survey. And as a result of that, we started offering virtual hearings or remote hearings, and that's what Thomas was referring to just now. So just to step back, I mentioned that we were going to look at 5 points to do with Delos. We've started with the institution. We then went on to thought leadership. We've talked about facilities. We've talked about some of what we do for the community. And perhaps the last aspect, if you want to have a full picture of Delos as an institution, is what we do more specifically on know-how as opposed to thought leadership and training. Now, by know-how, what I mean is staying abreast of developments, knowledge sharing, and sharing of best practices. And for that, we had 2 initiatives this year in particular, both online and still ongoing. One is a webinar series known as Tag Time, and the other a webinar series known as In Conversation with Neil. Now, I don't want to take up too much time on those, but if you go to our know-how section, you'll find both of them under in that menu. I'd like to say a few words about what we've been doing on the training front. Again, being responsive to needs, and you'll probably have gathered by now that this is a common thread in everything we're doing at Delos. The very existence of Delos is a response to needs. And the training we started this year was also in response to a need of the community. And that was demand for remote oral advocacy training, but for more experienced practitioners. So to frame it differently, many of us around the table have pleaded in cases before. We've got experience of pleading in a physical context, but what changes in a remote context? And how can we practice for that so that when we've got remote hearings, we're as sharp as we need to be? And so we created a program called ROPE. And this page shows you you can attend some of the mock hearings that are taking place. And the program has 2 components. One is oral submissions, the other is cross-examination. The program has gone very well, and so we'll be repeating it next year in different areas. And so if this is of interest, then obviously feel welcome to join us. I realize I've been talking for quite a while, and that's quite a lot of information. So maybe I'll hand the floor back to Agis to take it from there. Thank you.
Okay, thank you very much, Hafez, for the insight in Delos. Now, I have a few questions for you, but the first one is, what makes, we've heard about the Delos rules and basically allowing more discretion to the arbitrator to handle the proceedings. But isn't that a feature which we can find also in other sets of rules? What is it that makes the Delos rules special?
That's a fair question, and there's several aspects to answering it. I think the first thing is this. A lot of people talk about efficiency, and then in the same way as when we're looking at case law, you look at what people say and what people actually do. And what you'll find is that most institutions talk about efficiency, have a set of rules for small value cases, which is meant to address the need for efficiency. But that set of rules is usually related to a cap on the amount in dispute. And the underlying message is, we'll deal with efficiency by way of exception. And our view was no. If the need for efficiency is across the board, and that's the feedback we got from startups, from SMEs, from large law firms, from big operators, then the rules have to be have to work across the board. And then to keep this answer short, I'll just pause for a moment on the start of your question, which was rules refer to the need to be proactive or to be or for arbitrators to manage the cases. Actually, I'm not sure I entirely agree with that. There is a wisdom in arbitration that is best practice. But if you look at the actual language of rules, you'll find very few, if any, besides the Delos ones, that tell you expressly the tribunal should take an active role in the resolution of disputes. That's Article 7.4. The other thing you'll not find, in fact, is upfront a statement of principle about what are these rules for. When you look at arbitral rules, they just dive into the topic and they say, okay, so with this structure, you start your case this way and so on. But at no point do you have, or maybe you'll have a catch-all towards the end, which is there's this general spirit of the rules, but you will not have upfront a statement that says, what are we trying to achieve with these rules? And the point I'm getting at here is, and sorry, we've got that at Article 1.2, which is you want fairness, efficiency, and proportionate cost. And in the context of this webinar, everybody here presumably has a grounding in European law. And the analogy I want to make is you've got the detailed rules and detailed language you need to operate, but sometimes you need general principles to go back to know what is it that you're trying to achieve. And so that's what we've got at the start of our rules.
I'll just insist on that point with another question, though.
Yes.
Does this characteristic of the rules of Delos create an additional risk for the enforcement of awards?
Well, it's a fair point. I think it would if we were cowboys, so to speak. But you were kind enough to describe our bios at the start, and thankfully, Delos rests on more shoulders than just ours. We were fortunate to benefit from a lot of experience in designing the rules. And so what the rules represent is a collective wisdom of very experienced people. So yes, we've been innovative, but we've been innovative while within the context of best practices and experience.
One last question, and then we can look at any questions from the audience. Why did you choose London as the place where Delos will establish its arbitration center?
So
why not somewhere nicer or cheaper?
Well, maybe we should, but the reason was, again, looking at the needs of the community, London had a crying need for better hearing infrastructure. And we figured, let's start there and we can always go further afterwards.
Let's see if we have any questions from the audience, or if any of the speakers has any questions to address to each other. Okay, we're right on time.
Agis, maybe I can put a question to you if you don't mind.
No.
Which is, you've heard from all of us, and you were kind enough to to nudge us and to challenge us on what we were saying. But having listened to all of that, what is your takeaway, whether it's on the conversation about the seats or about the gap or about Delos? It would be interesting to hear your thoughts as well.
Well, I was involved in the gap, so I believe it's an excellent tool. It's the intelligence you can get from it in reading just a few pages is tremendously helpful. So I'm very much in favor of that tool, and I think it's very fair that GAR has decided to nominate it for an award. As in respect of the Delos rules, I have to admit that I haven't had any experience. I haven't had a case yet, but I've read the rules. I think that they're quite promising, and I think that they will be very appealing in disputes, especially in disputes involving parties from different legal backgrounds. And it is an area of special interest to me, the fusion of civil and common law procedure in arbitration. So I'm very much interested to see how it works in practice. But the simplicity and the inability of the rules, I think, makes it quite easily adaptive to the particularities of the local legislation on arbitration. So I think it should work very well. And I think it should fill in the gaps, especially with common law jurisdictions where the tendency is generally not to have proactive arbitrators. So it's giving this extra push and power to the arbitrator to try to forward the dispute in ways that he or she wouldn't be allowed to do otherwise. So I very much look forward to see how it works in practice, and I'm quite optimistic that it should work very, very well. Now, we don't seem to have any questions from the audience. It is 4:56. So, and I understand that Marilee would like to leave in a couple of minutes.
Yes,
so
indeed, I'm afraid.
So unless there is any other comment from the speakers, we could, I have a question, so let's wait. Anna. Anna is asking Marilee regarding the issue if the law of the seat on domestic arbitration is important in international commercial arbitration. That's the question put by Anna Plevry.
Right. Yes, I see the question. That's the inconvenient thing about the webinars, that we can't easily discuss and exchange. And exchange and clarify the question I meant. Because I'm not sure I understand the issue of the law of the seat on domestic arbitration is important in international domestic arbitration. I'm not sure whether the question is about comparing domestic and international arbitration or not. I mean, the whole discussion and the points I made at the beginning of the webinar had to do with the choice of seat in international commercial arbitration, so outside of the scope of domestic arbitration. Domestic arbitration is something obviously very not very different, but different when it comes to the rules that apply, and that varies from country to country. I think that my understanding is that right. So Anna responded that I have answered her question well. I'm very happy I have. Okay.
Well, I could just add there, I agree with Marilee. I would add that in cases where we have a seat at a place with a dual lex arbitri, one should also be looking at the definition of what is domestic arbitration in that jurisdiction, because you may be surprised sometimes. You may end up with a case that you would have thought that it's an international arbitration, but it would be treated as a domestic arbitration at the seat. So that's one issue that you need to be very careful with, but that's the only thing I wanted to add. So we don't seem to have any more questions, and I think we've run out of time. So thank you to all people who participated. Thank you to the speakers and to Delos for organizing this. And we very much look forward to keeping in contact with you in the near future. Thank you very much and have a good evening.
Thank you very much.
Very much.
Thank you.